So good afternoon, Your Honor. Mr. Moore is a 50-year-old man with AIDS, some related but different cancer, AFib, emphysema, diabetes, kidney disease, and several mental health challenges. I've seen the medication list. He's heavily medicated. What we're here today for is we're trying to set aside a default judgment. Mr. Moore slept through the hearing. It's his first hearing, and he was defaulted. He called, he set an alarm, and he asked his caretaker to wake him. Both failed him. He called the court right after, apologizing, right? Literally, that's the first time in almost 30 years of doing that I've seen that. So it wasn't intentional. It was a mistake. The Court of Appeals precedent we cite says, they're looking for intentionality and was it in good faith. He's extremely ill. He mistakenly slept through it. Then he immediately called to apologize. I think this is as good a cause as it gets, other than being hospitalized. The meritorious defense, and I just learned some new facts from counsel, which I think underscore the need. He's pled there's multiple conditions. Now, one of them is bed bugs, so much so that he's been sleeping upright in his chair, which also compounded him missing the hearing. I just learned from counsels that subsequent to an inspection that documented these conditions, they've been remedied. According to Mr. Moore, he's still suffering from bed bugs, and we went through the entire checklist of what they're supposed to do if they have bed bugs. None of it, and there's a bed bug rider, but they're very clear in the bed bug rider, they're not pushing responsibility off on the plaintiff because ultimately they can't. Maintenance responsibility is theirs. He did what he was supposed to do. He had the caretaker help him. And he's got a right to an abatement based on those to the extent they've ended, and he's got as counsel claims, or a continuing abatement to the extent they're going. And I've got a number of pictures here. So we think he's entitled to his day in court on those defenses. Now, that said, Hawk, if we can get these things fixed, Hawk has committed to paying the back rent. Mishta is supposed to pay his part, although then again, I just heard something that we haven't heard before. There's some issues. Counsel has said Mishta has suspended his payments, which we were in contact with Mishta last week. We never heard it, so I'm not sure who's saying what. He's got a right to his day in court. We think justice requires it, particularly given his age and extremely fragile health, where an eviction is not going to help at all and going to be severely detrimental. And ultimately, we just want to work this out. Counsel seems amenable to that. He wants a judgment. At this point, we don't think it's proper. We also think it's going to harm his continuing eligibility for Mishta. So we would just ask simply that the court set aside the default, put the case back in, let us get the plaintiff their money, and to the extent that there's continuing conditions, let's get them cleared up, and let this person who's not in great shape continue to try to tend to their well-being.
Okay, thank you. Response, Mr. Muda.
Thank you, Honor. So as Brother Counsel stated, this is a very sympathetic defendant, and of course I'm sorry for that being the nature of this situation, but I'm fine with the good cause that's provided. It's the meritorious defense that I'm having trouble with here, Your Honor. The repairs that defendant is concerned about, he submitted a letter to property management in regard to those repairs on August 9th. The repairs were things of the nature of, he listed bed bugs. In addition to that, he listed like a leaky faucet, a cabinet that needed to be fixed, and issues that I do not believe amount to habitability concerns. But even if they did, there was an inspection that was done by the city on August 29th They were passed on September 5th. I do have the past inspection that was provided here. We also had an exterminator that was sent out to the property. The exterminator did not find any bed bugs after doing the inspection of the property. And so the alleged bed bugs that are supposedly an issue in this instance were not noted at the property to any degree, with the exception of a pill capsule that the tenant had that had a bed bug in it. That was his indication for when they existed in the apartment. The tenant provided to the inspector that there was a bed bug maybe back in July that he had caught. Since that time, we've had both a city inspector and an exterminator come out. The city inspector once again passing the property, and then in addition to that, the exterminator not finding any bed bugs in the location. The defendant has lost his voucher and is unable to pay. He indicated with an email to property management stating that money had been removed from his bank account, and so he was unable to make payment. This isn't a situation of, you know, the property being uninhabitable and the tenant simply withholding money based on that. This is a situation where unfortunately the tenant is unable to pay, and so for that reason, he's throwing everything at the wall just to see if it sticks. And the city inspection, in addition to the exterminator, would indicate that that's not the case here. The repairs that were alleged, once again, not amounting to major habitability repairs, nothing that would affect his use of the property. And then in addition to that, if there were anything that would be considered to a degree of problematic, they've been remedied at this time, and I believe within a reasonable time frame, Your Honor.
Thank you. So I was surprised to hear you say that your dispute was with the meritorious defense piece. So can I see counsel in a breakout room?
Certainly, Your Honor.
Yes, Your Honor.
You always seem to come at that time. Is Mr. Mudar and Mr. Santacroce. All right, thank you. We're back on the record in the Laurel Bay versus Robert Moore matter. I went into a breakout room with counsel and explained some additional documentation that the court needs in order to make a determination about whether or not this case is going to be reinstated. It's my understanding that the plaintiff is going to provide a copy of any and all reports that were provided during any inspections, and that the defense is going to provide a copy of any and all documentation they have, whether it be in the form of pictures or any other documentation to support their claims with respect to any abatement or habitability issues. And we will have those documents exchanged to each other and provided to the court by hopefully by the 12th or so. And then the court will have an opportunity to look at it, and we'll have a hearing again on the 19th and make a decision as to that. In the interim time period, the parties will be, well, Mr. Santacroce's office will be following up with respect to any financial assistance that may be available for Mr. Moore. Is that a correct statement of what we discussed?
Yes, Your Honor.
Thank you. We'll see you all then on November 19th, 2025 at 3 p.m. Have a great day, everybody.
Thank you, Your Honor. Union Court staff, have a wonderful rest of your day.
Thank you. You too. We'll call the case of Huron Heights and Huron Ridge versus Michael Wood, case number 25C 4009.
Amy Brownlick on behalf of the plaintiff.
Michael Wood.
Thank you. Good afternoon. Mr. Wood has filed a DC 539 form also.
Yes, I spoke with Mr. Wood. He indicated he is still waiting on a decision from DHS. He indicates he does plan to vacate by the end of the month, but he's trying to get the balance paid up. So I think in this case, we'll likely have to adjourn if there's still not a decision yet.
All right. So he's vacating when?
By the end of November, he stated.
End of November. Okay. All right. Do you want the 19th or the 12th?
I'm okay with setting it over to the 19th. Unless, let's see. I don't know if you have any preference based on your docket at this point.
The 19th is my preference, but I'm gonna do
Okay.
what is needed. Mr.
Fine.
What is your thought on your next court date? It's in person on November 19th. It's via Zoom on November 12th.
I don't have a preference. It's whatever. Just whenever they'll respond, I'm waiting on DHS.
All right, then I'll give you until the 19th. That'll give them additional time to respond. November 19th, 2025, and I'll do it at the same time, 1:45 p.m., okay?
All right, thank you.
Thank you. Have a good day. We're here on this third hearing for non-payment of rent. There is a DC 539 form that has been filed in this matter as well.
Yes, Judge, in this case, I did speak with Miss Walker. She was denied, she was denied receive any assistance through DHS. When we met in court last week, she had made an agreement to make a payment of $1,000 last Friday. That was not paid. And speaking with her, she was agreeable to a consent judgment, if I could state those on the record.
Thank you. You may proceed.
We have rent retained in the amount of $6,320. Other money due of $426. Court costs of $163 for a balance of $6,909 with a pay date of November 17th, 2025.
You said November
17th.
17th. Thank you. One moment. Oh, sorry.
That's okay. We're all set, Your Honor. We're back on the record.
All right, the recording has stopped. All right, so we are back on the record. The court will advise you, ma'am, that you have a right to have a hearing as to the amount of rent that is owed. Is it true that you are going to not have a hearing? You're gonna agree that you owe $6,909 in total?
Yes, Your Honor.
And that you need to have that paid by November the 17th, 2025?
Yes.
You either need to do that or move, otherwise they can come in and request that the court issue a writ of eviction. And they can come in as early as November 18th to do that. You understand that?
Yes, I do, Your Honor.
All right. All right, I'm going to grant a judgment by consent for possession only in the amount of $6,909. And you'll have 3 business days from the date I sign this agreement to petition the court to set it aside for a really good reason. It's rare that I do that though, okay, ma'am?
Okay, Your Honor.
Do you have any questions?
No, that'll be all, Your Honor.
So if there's a writ of eviction, you need to understand that the sheriff's department will come out and they'll only give you 24 hours notice to move. So you need to either be prepared to pay or to move by that date, ma'am, okay?
Yes, Your Honor.
All right, have a good day, ma'am.
You
Judge,
too.
I should
Thank
add,
you.
she did give me permission to sign her name to that judgment, and I do have her email address, so I will send her a copy when I submit it to the court.
All right, thank you. So ma'am, from when you submit it to court, if it's any time before, say, 4:30 today that it's submitted, you could probably presume that I'm gonna sign it before I leave. So you have 3 days from today's date, okay?
Okay, Your Honor.
You're welcome. Bye-bye.
Have a good day.
Thank you. Huron Heights and Huron Ridge versus Jocelyn Fox, case number 25C3995.
Brownlick on behalf of the plaintiff.
Jocelyn Fox.
Thank you. We're here in this third hearing for non-payment of rent.
Yes.
Yes, Judge. I spoke with Ms. Fox. I believe there is a DC 539 on her
Yes.
file. And
I just
she,
sent it in.
I don't see it in the file yet. She may have submitted it today, but I don't have it in.
Yeah, I did. I submitted it today. I think I accidentally submitted it to the wrong email last time I had it. That's why I asked Miss Brittany today what the email address was. That's why I resubmitted it today. I am so sorry. I'm still waiting for a decision from DHS, and I have a Hawk meeting tomorrow at 2:00. And so I don't know if I'm gonna get a decision from them either. I don't know.
I will let you know that the Hawk does have some funding now. I don't know whether she qualifies or not, but there is funding that is available at this
Oh,
time.
good. Oh, That's fantastic.
I believe it's worth holding off to explore that. Obviously, my client does want to proceed forward. It was my understanding Ms. Fox had timely submitted a DC 539 according to my conversations with her, but considering she does have an appointment tomorrow and is awaiting that decision from DHS, I'm willing to adjourn it based on that.
Ma'am, I'll adjourn this to November 19th, 2025. It is in person at 1:45 PM, okay?
In person, okay, I'm disabled. Is there,
There's a form you can fill out and submit to the court. You can call the clerk's office and then they will advise you how to fill out that, or advise you how to get the form so you can fill it out, not how to fill it out, but how to get
okay.
the form, okay?
Oh, okay, I call the court.
Yeah, the court clerk here at 14B District Court, ma'am.
Okay, great. I will do that. Thank you.
Thank you.
You, Judge, I believe that's the last of my cases.
All right, thank you, Ms. Barling. Have a good day and I'll see you next week.
All right, thank you. You too.
Thank you. You guys have a good day.
You too, Ms. Fox. Swan Creek versus Joanne Black and Sheldon Marks, case number 25C 4146.
Good afternoon, Your Honor. Attorney Carrie Zanon on behalf of plaintiff.
Hello, Ms. Zannon. I dropped the gun and started reading your name into a different case.
I know you had me like distracted for a minute because I was working on something. I was like, wait, did I miss something? Judge, I'm glad to see you. I know
Thank
things
you.
have been going a little crazy for you. Thinking about you,
Yes,
Judge.
they have. I appreciate that. You don't anticipate something like this happening, but you got to work through it. And so that's what we've been doing. So
I have something not like that, but similar with my son. Not similar, but situational. And I understand, Judge. I truly understand.
thank you. I appreciate it. Is Joanne Black or Sheldon Marks present? If so, please state your name.
Sheldon Marks.
Thank you. All right, we're here for the second hearing in this non-payment of rent matter.
That's correct, Judge. I did speak with Mr. Marks. As to Joanne Black, she's not present, and I'd be requesting a default judgment. As to Mr. Marks, we've agreed to a consent judgment, rent to retain $3,413, court costs of $214 for a total of $3,627, with an extended writ to issue date of November 21st, 2025. It's a possession judgment only. Further orders will say if he does either pay or vacate, plaintiff will set aside and dismiss the case. I explained to Mr. Marks his rights under MCR 4.201J, his appeal rights. He's given me permission to sign this consent judgment on his behalf. Is that correct, Mr. Marks?
Yes, ma'am.
Thank you. All right, so you do understand you have a right to have a hearing as to the amount of rent that is owed, but you are going to not have a hearing and you're going to agree that you owe a total of $3,627.
Yes, ma'am.
All right, and you're gonna pay that no later than November 21st, 2025, correct?
I'm going to try my best.
All right, if you fail to pay it or you fail to move, so you gotta do one or the other, they can come back in here on November the
24th.
4th and ask for an immediate writ of eviction, giving you only 24 hours notice to move. You understand that part?
Yes, correct. But I was also informed if I talk to management, if Missy agrees to give me a couple more days, because my lease is up at the end of the month anyway, so I'm already moving. I'm just waiting for the house to be available for me to move in. I got so I'm on layoff right now. I plan on paying them. I'm just waiting for my unemployment to finally kick in through my work. That's the only reason why I haven't made payment.
Okay.
So, but yeah, I plan on being out this month. So
Well,
yeah.
I can't, so any agreement that you have with them about whether or not manager's gonna get extended time, that's not a part of what this court order would do. Okay, that's between you and management if you decide to do anything separate from that, okay?
So as long as I have written proof from them, though, I should be fine, right? As long as they agree to it.
If they've agreed to it, they're the only ones that's requesting a writ. I don't just issue those.
No, I get that.
So,
I'm sorry.
yeah.
I'm a young man. Like I was explaining to her, I'm in the process of taking my daughter to the hospital because she's got a knee appointment at U of M. So I'm trying my best.
I get it. So yeah, as long as they agreed to it and you got something in writing, you should be fine, but I can't give you legal advice. I'm just telling you that this order that you're agreeing to is by the date of November 21st, okay? All right. You'll have 3 business days from the date I sign this agreement to petition the court to set it aside for a really good reason, but it's rare that I do that because I try to make sure everybody understands their rights, okay?
Okay.
You're all set, sir. Have a good day. You can sign up when you so choose.
Thank you, Judge.
Thank you.
Thank you.
What we'll call the matter of Lake Point Trafalgar versus Kendra DeGraffenreid, Reed, case number 25C4139.
Good
Yes,
afternoon,
Kendra,
good afternoon, Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Ms. Cohen,
Kendra DeGraffin Reed.
thank you. We're here on the second hearing for non-payment of rent.
Yes. Oh, I don't know.
Ms. Cohen, where are we, please?
We have a consent judgment to put on the record, Your Honor.
May proceed.
Yeah, we've agreed that there's a total of $3,492 owed in rent, $168 in court costs, for a total of $3,660. The writ date would be 11/17, but it will say no writ will issue as long as defendant pays $1,830 by November the 17th and $1,830 by November the 28th. And she did give me permission to sign her name and electronically submit it to the court. I have not gotten an email address. I don't know if you're able to put that in the chat, or you can just tell me what it is. And I'll make sure to get you a copy of it.
The preference is that you put it into chat, ma'am, so that because this is it's live.
Okay.
So the world hears it. So do you know how to put it in chat, Ms. DeGraffin Reed?
I can try that right now.
Okay, you know what? I'm sure that Lisa has your email.
Yes, she has my email and phone number.
Perfect. I
Okay.
will get it from the manager and I will email it to you, okay?
Okay. I'm gonna send it just in case something happens,
Okay.
but
Perfect.
I am,
Ms. DeGraffin Reed, you understand you have a right to have a hearing as to the amount of rent that is owed and costs together for the total. You have a right to have a hearing on that?
well, I'm aware now, yes.
Okay, but you're gonna agree that you're not gonna have a hearing and you're going to agree that you owe, and I'm not sure I got the number right. I believe it's $3,660.
Yes, and 1830 on the 17th and 1830 on the 28th.
Okay, thank you. And as long as you pay that, then everything will be fine. You failed to pay it either one of those days, and they can come in the next day and ask for immediate writ of eviction, giving you only 24 hours notice to move, okay?
Okay.
You'll have 3 business days from the date I signed this agreement to petition the court to set it aside for a really good reason. They're gonna send it to you in email, so you'll know when the court gets it. You can presume if it comes to me before 4:30 today that I signed it today, okay?
Okay.
Any questions?
No, that'll be it.
All right, you're all set. Have a good day, ma'am.
You too. Thank you.
Thank you. So we'll call the case of Lake Point Trafalgar Limited versus Rhonda Wright, case number 25C4141.
Good afternoon, Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Rhonda Wright present.
Thank you. All right, we're here for this second hearing and now for non-payment of rent.
Yeah, we have a consent judgment to put on the record, Your Honor.
You may proceed.
We've agreed that there's a total of $3,621 in rent, $168 in court costs, for a total of $3,789, and that those amounts will be paid by November the 17th. That's the writ date. And Ms. Wright did give me permission to sign her name to this and electronically submit it to the court. Ms. Wright, do you have an email that you could put in the chat?
Yes.
Okay, and then I will email it to you, okay?
Okay.
Thank you.
Thank you
So
so
when
much.
she submits it to the court, she submits it, she CCs you on it so that you can see that it's been submitted to the court, okay?
Okay.
You have a right to have a hearing as to the amount of rent that is owed. You are going to agree to not have a hearing. You're gonna waive that hearing and agree that you owe $3,789. Is that correct?
Correct.
You'll pay that no later than November 17th, 2025. If you fail to pay it by that date, they can ask for a writ of eviction, giving you only 24 hours notice to move. So they can be here as early as November 18th asking for that writ of eviction. You understand that?
Yes.
All right, I will sign this agreement. You have 3 business days to petition the court to set it aside for a really good reason. Like I told everyone so far today, if I get it by 4:30, you can presume I signed it today, okay?
Okay,
You're all set. You can have a good day.
thank you.
Bye-bye. Good afternoon, sir.
Good afternoon, Your Honor. I've made contact with Miss Reffitt. We've arrived at a settlement. I provided her with a DC 508 consent order for conditional dismissal. She's at work today, so I told her that I would inform the court that I told her that she did not have to appear, and she's going to print and sign the conditional dismissal when she gets home from work this afternoon, which I will then submit to the court.
I'm gonna set this for a date, EO date. Been gone so long, I forgot my own terminology. We're gonna do an entry of order date and we'll schedule this. You think 2 weeks, you should have that into the court by then?
I'd like to think I'll have it in the court by tomorrow, Your Honor.
I hope so,
Yeah.
but let's go. Do you want me to put it on for the 12th just in case it doesn't come back, or to the 19th? The 12th?
Whatever works best for you, Your Honor.
I'll
Both are
put it on for the 12th for you because the 19th is in person, okay? So
Thank you, Your
November 12th, 2025 at 3 p.m. As long as the order is in, it won't be on the docket and it won't be called. If the order is not in, then I'll
Then
need
we'll
to
talk
see
some
you
more.
guys, okay? Thank
Thanks,
you.
Your Honor. Thank
Have
you.
a good day.
You too.
The court will call the matter of DT Financials LLC versus Samuel Freeman, case number 25C4160.
Good afternoon, Your Honor. William Babbitt representing the plaintiff, DT Financial.
Good afternoon, Mr. Babbitt.
Mr. Freeman
Samuel
is also.
Freeman. Please, please state your name for us, sir.
Yeah, I'm Samuel Freeman.
All right, thank you. We're here in the second hearing for non-payment of rent.
Yes, Your Honor. Your Honor, Mr. Freeman and I have had an opportunity to speak, and what we have agreed to is to have set a move out date of November 30th of 2025. And if Mr. Freeman comply, we're going to enter a consent order for conditional dismissal. It calls for that. We're not asking for a money judgment in this case. And if Mr. Freeman moves out by November 30th of 2025, then we will not be seeking any further remedy. Otherwise, of course, if he does not move out by that date, then we would then be able to submit an order of eviction for your signature. And I have prepared a consent order for conditional dismissal. Those are the terms. And Mr. Freeman and I have discussed those. And Mr. Freeman, if those, would I be able to sign your name to the judgment as we've just discussed? Am I getting ahead of myself, Your Honor?
Yeah, the dismissal. Would
Yeah.
you be able to sign your name to that, sir?
Pardon me?
I was asking Mr. Freeman if he would agree to allow you to sign his name to it. Have you sent it to him yet? I think he would probably want to review it first, Mr. Babbitt.
I have no problem with that.
Okay.
Your Honor. We do have plenty of time here.
So, Mr. Babbitt, so Mr. Freeman, I'll start with you first. You understand you have a right to have a hearing as to the amount of rent that's owed, but you're going to just forego a hearing on that and agree to a dismissal in this case, where if you move out by November 30th, then the case would just be dismissed and it wouldn't be on your record. You failed to move, then they're going to be able to get a writ of eviction, and they can ask me for that writ of eviction as early as December the 1st, and it would only give you 24 hours notice to move. Okay?
Okay, I understand that.
Is that what you want to do?
I do want to do that. I would like to ask about the security deposit, but as far as everything else, I've agreed to.
Okay. And what is it that you wanted to ask about the security deposit, sir?
We had previous discussions, me and Mr. Richmond, about that being returned. And when I was talking to Mr. Babbitt, I forgot to bring it up.
Yeah, I don't think he's going to agree to that, Sam. We are waiving the rent claim. And I think that was something that he offered to you before I really kind of got involved. You
Why
know,
don't
this
I let
is,
the two of you want to talk some more? So I
I mean, we can, but Your Honor, he's not going to agree to that. So I mean, this
well,
is
and
kind
then
of,
he might not agree to what you're saying, so you should at least,
yeah.
we should at least know where we are with things.
I mean, what do
Yeah.
you think, Sam?
Could we maybe discuss it just for a couple moments and then come back?
Yep,
We can.
I'll let you do that. I'll pass this. I'll recall it in a few minutes when I see you both return. What will call the case of Swan Creek versus Tiffany Peterson, case number 25C 3830.
Again, Attorney Carrie Zanon on behalf of plaintiff, Your Honor.
Tiffany Peterson.
Well done, everybody. We're here on the fourth hearing for non-payment of rent.
That's correct, Judge. You know, it's my understanding that Ms. Peterson made a payment, but she also is receiving a check from Hawk. The check has, I believe, been processed, but I went back in the breakout room to verify if my client had received it. She has not received it. They believe to receive it within the next 5 days. Can we just have a brief adjournment? I know that. Oh,
I have an email. Can I read it to you?
Judge, I don't have a problem with her reading it, but regardless, my client verified with me this afternoon that she hasn't received the check. So I would just ask for a brief adjournment so we can get that and then we can dismiss the case.
All right, give me one moment. Miss Amy has actually turned on her camera. Good afternoon. Amy. How are you?
Good afternoon, Your Honor. With Ms. Peterson's permission, I could add maybe just a little bit, but not too much more.
All right. Ms. Peterson, do you give Miss Amy, who is from Hawk, permission to discuss your case with us here on the record?
Yes.
Thank you. All right, Ms. Amy, you may proceed.
Thank you so much. So the amount is $2,321.30. It was just requested and approved today. And I don't have information about the mail out date and once it is mailed out, how long it will take. But Alicia's working on it, Carrie, Ms. Yannon, so that if you wish to further pursue that detail, I'm sure she'd be happy to provide it.
Sure, yeah. Yeah. So Judge, I think a brief adjournment is appropriate as this will then cure the remaining balance on her ledger.
All right, and so when you say, what do you say, calling brief, November 12th, November 19th, November 20th?
Well, let's do the 19th just in case, Judge, because the mail is just awful. So there's that if it's being, unless, but I can follow up with them.
Are they sending a letter of, a decision letter that would allow you to dismiss it? Assuming that you get the check, if you don't get the check, then of course it could be reinstated. So she doesn't necessarily have to appear here in person on the 19th because they are in person on November.
Okay, they are in person on the 19th, and I knew that, Judge. Yeah.
My docket starts in person on that date for landlord tenant.
Yes, Judge.
November 19th, 2025. And that's going to be timed at we have this one at. I'll put it at 2:15 p.m. again. Okay.
Thank you, Judge.
Thank you. So as long as they have the check or decision letter from Hawk by then, ma'am, you won't have to show on that date, but make sure you reach out to the Cox Law Firm to confirm what's going on, okay?
Okay.
All right.
All right. Thank you so much.
You're welcome. Have a good day.
Have a good day.
Is Mr. Freeman back? Okay, the court will recall the matter of DT Financials LLC versus Samuel Freeman, case number 25C 4160.
Good afternoon again, Your Honor. William Babbitt representing the plaintiff, DT Financial. I've had an opportunity to speak with Mr. Freeman, and the terms of the consent order for conditional dismissal are, as I indicated to the court earlier. He will move out by November 30th. He did give me his email address, so I will submit this copy of this proposed consent order to him to review. And if he gives me permission, or he could come and sign it in person, we will then submit it for your entry. And that is the entire agreement. Again, we're not taking a money judgment. And that's our agreement.
Thank you. All right, Mr. Freeman, we placed the agreement on the record again. Is that your understanding of the agreement, sir?
Yes,
All right. And so you're gonna waive a right to have any hearing. You're gonna agree to move out by November 30th and the case would be dismissed, correct?
yes.
All right. All right, I will sign that agreement upon its presentation. Mr. Babbitt, just so that we have a tickler date, I'm gonna give you an entry of order date. And I'm gonna make that for next week, November the 12th by 3 p.m. So it needs to be in by then, okay?
No problem, Your Honor. Thank you very much.
You're welcome. If it's in, nobody needs to be here. So, sir, if it's not in, you also need to be here. So you need to sign that and send it back to them as soon as possible so that it can get off the court's docket. Okay?
Okay, yes, I understand.
Thank you. Have a great day.